Yes, thank you very much for this opportunity. I'm really honored. In fact, I see in this room also many people I've been working with in these years for a better regulation of AI from the perspective of protecting human rights and protecting vulnerable groups, including children. So thank you for this opportunity to bring a bit of elements of this work into this discussion. Because in fact, we need the companies to do their part. We heard from one, we need institutions to do their part. But I think we cannot rely only on voluntary commitments, on goodwill. We need rules because we have seen already, especially dealing with the digital issues, with the digital space, that when things change, if there are no rules, everything can change very rapidly in a different direction than the one everyone committed to, because the context might change. And so you need to have more than just guardrails. Obviously, you need to have the instruments to do that. And in the EU, we fought to have the first ever horizontal legislation on AI, the AI Act, which in fact includes, in its interaction, I would say, with other EU legislation, some important safeguards for children. I say with interaction with other legislation because for the examples I will make now, it's clear that the interaction with the Digital Services Act, that is another important piece of legislation, is very important. The Digital Services Act deals with the regulation of the platforms, the social media that we all know, while the AI Act deals with the systems that operate with AI, including the generative AI, that is especially important in this debate. I give you a few examples based on the Act. The Act prohibits certain use cases of AI. The presentation that we got from Cécile Aptel at the beginning has shown, for example, that there is the prohibition with the AI Act in place for manipulative methods towards vulnerable groups, including children. This is part of the EU AI Act. The slides were saying it should be like in the EU because we already prohibited the manipulation of children, in general of vulnerable groups, that can cause harm. And this is one of the most significant prohibitions in the law because manipulation also with subliminal techniques is absolutely possible with the use of AI. And we have prohibited the emotion recognition in places of study. This also affects children. We do not want children to feel the use of AI in an intrusive way towards them in a place where they are learning in schools. And we fought of that for various reasons, including not entering into the privacy of a minor, to prohibit that in schools. But then, moving from the prohibitions, in fact, the regulation of the so-called sensitive use cases, high-risk use cases, as they are called in the law of AI, we see again the impact on minors, because we can look at, so these are authorized uses of AI, they are not prohibited, but they are regulated, they are made safer. And you see, in fact, the interaction with children in educational institutions. First of all, when evaluating their learning, so to interact with them as students. These are considered as high-risk use cases because they could lead to discrimination or to a lack of protection of the data of the children. And so these are a typical example of a use case like others, like the use of a doctor towards a patient, like they use in courts, like they use in the workplaces. These are other examples of so-called sensitive use cases. Also, the use in the educational facilities to evaluate and monitor the educational path of a child is considered a sensitive use. So those that put systems in the market, in the society, by the educational institutions in this example, systems that have this use case, they will need to follow certain parameters of conformity to demonstrate that they are checking for the safety of the system, in the sense of the quality and appropriateness of data used to train the system, cybersecurity, governance of the data, which is very important for children, and human control over the system. So these are examples of, in fact, what we see in terms of a conformity assessment. I give always this example. It's like in Europe when we look for products that are foreseen for consumption, food, drinks, or toys, to talk again about children, we need to check that they respect certain rules. We do not want dangerous products of all these kinds. I made different examples, I mean, different from AI, but it's the same with the AI. We want them to be safe. And for children, this means checking for these specific issues. When I talk about quality and appropriateness of data, this means that the data used to train the AI system need to be appropriate for a system that will interact with children, with that specific use case. The AI Act is all based on the idea of regulating use cases. We do not regulate the technology per se, and we do not regulate businesses. We regulate the use cases of the AI, including these ones that are linked to users that are children, that are potentially minors and in general vulnerable subjects. Then probably the most important part for this discussion is the third. In my view, it could be the most important, even though prohibitions and the high risk is also quite important. It's the transparency part, because the transparency part is dealing especially with the impact of the generative AI, which has been at the center of the previous attention, also the previous interventions, and in general, it's very much at the center of our attention when we deal with protection of children. What are the provisions? Well, they go very much in the direction of what we heard also from the previous interventions of this afternoon panel. Because first of all, they indicate to the general purpose AI systems that are working as generative AI systems for the use of millions or even billions of people today, to put in place all the precautions to avoid the generation of illegal content, of hateful content, of violent content. Clearly, this is something that has a margin of appreciation. It's not able, just this prohibition, to solve everything. But first of all, there is this, well, I wouldn't say prohibition, I used the wrong term. We would say push to limit as much as possible, because probably removing it completely is not possible, but pushing to remove as much as possible the capability to generate the content that we, in fact, are struggling today to remove from the social media. Because, in fact, what the AI Act is trying to do is to prevent what today we have been struggling with the DSA, with the Digital Services Act, and other voluntary commitments and code of practice and various ways of doing. We have been working to remove, to cancel, to correct. But we are trying with the AI Act, in fact, to do more in terms of prevention, not just correction. So to prevent the generation of certain content that is dangerous, that is offensive, that is violent towards vulnerable groups, including children, and to Also, that was also mentioned in the presentation we heard from Ms. Aptel, the clear indication to prevent any behavior from those generative AI of pushing the user to commit criminal or harmful behaviors. So the classic examples we unfortunately have read of those that push people towards self-violence and suicide. This is clearly stated. They have an obligation to demonstrate that they have put all the efforts to stop this kind of usage by the generative AI. But then, very important, in my view, is the general transparency obligation in making AI-generated content recognizable. I think this is very important because it's the obligation to have a functioning system of watermarking that will make every device able to identify the synthetic origin of a content so that a manipulated content, a deep fake content, think of how much cyberbullying towards minors could be done with deep fakes. It's already being done. It's a matter of extreme suffering for the mental health and the well-being of children. This would help a lot identify immediately this kind of abusive deepfakes, because every content that is AI generated will be labeled in a way that will be identifiable directly by the device. It will not be dependent on the social media platform. This is extremely important because I say that also as a politician, to give a very different example. We have seen already materials of deepfakes manipulating the political discourse. You can ask this to be removed from the social media. In fact, the European laws, like the Digital Services Act, help us doing that. But while you remove it from one social media, you risk this content to be in a lot of other places, and you can't just catch it everywhere. While with these rules for any kind of abuse, so I mentioned now the political one, but this applies obviously to the minors' abuse and violence, the content can be identified immediately as manipulated or AI generated with any device, and this will be brought around with the different context. Technically, it's difficult. We are working on that. But this is what we are asking the companies to do. And to be frank, when we started working on the other transparency aspect that I will not get too much into because it's less relevant for this discussion, which is the protection of copyright. When we started working on this, on the first topic I just mentioned, the recognition of materials, suddenly all the big companies said they were absolutely ready to do this transparency of making content recognizable, because they didn't like the one on the copyright, because that's where the money is, to be very honest. It's an issue that has to deal with a lot of economic interest, because it's the balance between innovation and using of copyrighted material. So to be frank, we can say that if we want, it's possible to bring much more transparency. We have seen commitments in this sense with the Hiroshima G7 process on generative AI. We have seen that with the commitment at the Munich Security Conference by the, especially dealing with fake news, but the principle is the same, by the main developers. So with all these voluntary commitments, now it's time also to be clear that we respect the laws, and the European Union has now a mandatory law, not only an invitation to behave in a good way. I think this is very important to set also a standard at the global level. I was at the IGF, the Internet Governance Forum of the United Nations, just a few weeks ago, where all the countries of the world are present. And our work also in the protection of vulnerable groups, including children, is well observed by a lot of different countries in the world that are thinking of how to regulate on these matters. And I think that it's important that we do not backtrack. I'm saying this because we are in a moment where on these topics we are under a huge pressure to just backtrack and change course. I think we should not, because we are setting, I think, good standards, especially for the topics we are discussing today. And to conclude, I would like to say that the legislation that we have put forward, including further work that we are doing on, that is now being discussed in the institutions on the liability on harm caused by AI uses, to clarify who should pay for damages. So in fact, we are still working on these legal aspects, as to be complemented with a big effort by the institutions on, and this was also mentioned in the previous interventions, on AI literacy. This is something where we have been advocating for. It's clear also in the AI Act, but this needs further work by the member states in the EU, by the governments in the world, and by all kinds of institutions. Because I think that building consciousness, building understanding of what we are talking about, and so to avoid any form of manipulation also by building more consciousness, is also extremely important. I want to reiterate that I don't think that these are in contradiction. We need some ethical approach. We need ethics, which means to deal with these issues with a value-driven, human-centric approach that is above the law, that is outside the scope of the mere legislation. But to make this effective, I think we really need also the legislation in place, to avoid that there are those that just ignore the ethical approach, that they just try to get, that they just care about profit, to be frank, or other objectives that are not the common good. So we need a combination of goodwill and ethical approach, of laws, and we need also education. We need learning. We need to invest in this effort to bring more consciousness on these issues with the teachers, with the children, with the families. And I think this is something where we need to make further steps together. Thank you very much.